Hello, how are you all? Welcome to my channel Law Made Simple with me Vidyarthi. Today in this labor law, let us learn a new topic, layoff. How does layoff got introduced into the ID Act 1947? We have a big history regarding this. The terms layoff and retrenchment were not originally incorporated in ID Act 1947, but when there was a great famine in West Bengal during 1950s, the employers failed to provide employment to large number of workers, and this resulted in industrial unrest. So, because due to non-availability of raw material and worst marketing conditions, the employers terminated the workers from the services, and this became a big hue and big blow to the poor workers. So those who were serving the employers from long period were on the roads. Finally, the government, with view to provide financial assistance to these workers who were terminated from the services, the government has introduced the terms layoff and retrenchment to the Act of Industrial Disputes Act 1947 by an amendment in 1953. So, the layoff got introduced by the government during 1953 amendment. Let us look into the definition of layoff. Layoff is defined under section 2KKK of the ID Act. What does this definition say about? An employer who is willing to employ but fails or refuses or is unable to provide employment for the reasons beyond his control. The layoff may be declared on the account of shortage of coal, power or raw materials, or because of the accumulation of stock, or if there is a breakdown of machinery, or due to natural calamities or any other connected reason. So, the employer who is laid off should have that workman must have been, the name of the workman should have borne on the muster rolls of the industrial establishment, and he should not be retrenched anymore. So, this is the definition of layoff. Let us look at simple meaning. Layoff means putting aside temporarily. The employer-employee relationships does not come to end but is just nearly suspended during the period of emergency. And the duration of layoff should not be longer than the period of emergency. Is the procedure of layoff. Every workman who presents himself for work at the time appointed and he is not given employment within 2 hours of his presence, he is deemed to have been laid off for that day. If such workman is asked to present himself for the purpose of work during the second half of the shift and is given employment, he shall be deemed to have been laid off for 1/2 of that day. If such workman who is asked to present himself during the second half of the shift and is not given employment, it is deemed that such workman has worked for that day and he is entitled for full wages for that day. So this is the procedure for layoff. So how is the layoff compensation paid? Section 25C of the ID Act 1947 enables a workman to get compensation from the employer for the period he has been laid off. How? When an employer is unable to provide work to his workman for the reasons beyond his control, he has the duty to pay layoff compensation to such workman. Who can claim? To claim compensation, the workman should fulfill certain conditions. The name of the workman must be borne on the muster rolls of the industrial establishment. He must not be a badli or a casual workman. He must have completed at least 1 year continuous service for 190 days in case of ground service in the mine, or 240 days in any other case. So these are the rules to get layoff compensation to such workman. How is the rate of compensation calculated? A workman who has been laid off for reasons contemplated under the provided section is entitled for the compensation equal to 50% of his wages and also the dearness allowance, and the dearness allowance is paid in full. And if such layoff is exceeded for 45 days or more, then the employer can retrench the workman and he can pay full retrenchment compensation. And if any layoff compensation is has to be paid to the workman, then he can set off against the retrenchment compensation. And who are the workmen who are not entitled for this compensation, layoff compensation? Under section 25E of the act, the layoff compensation is not entitled if the workman is not present himself for the work at the establishment and at the appointed time during the normal working hours at least once a day. If the workman doesn't sign the registered, then he is not entitled for compensation on that day. We have a case law regarding this in Nutan Mills Limited versus Ahmedabad versus ESI Corporation. The court held that layoff period, the relationship of master and servant is suspended because the master cannot provide work because it is beyond his control. If the workman refuses to accept alternative employment provided by the same employer, either in the same establishment or in other establishments situated in the same town or village or situated within the radius of 5 miles from the establishment which he belongs, if he doesn't go there, he is not entitled for compensation. What is that alternative employment means it is similar kind of employment but not in this factory but in another factory. He has to accept. If he doesn't accept, he will not get compensation. If the workman accepts this, then he will not get layoff compensation because he is getting the normal wages. So all these rules and regulations are laid down under section 2KK of the ID Act.